Hey, it's Chris Burns with another Coffee Chat, and joining me today is David Wasson. How you doing today?
Doing well. How about yourself, man?
Good, good, good. Thanks for coming on the show. Now, we're going to talk about something today that's, not fun to talk about, but it really is part of estate planning, and then also wealth management, death of a spouse.
It's really hard to swallow for a lot of people. It's really something you don't want to think about. I mean, that's the person that you chose to spend your life with, so you definitely don't want to ever see any harm to them. But unfortunately, it is a reality. Everyone is going to die one day, and you got to make sure you have things in place for that.
Now, from a wealth management standpoint, I'll talk in a second, but I want to lead with the estate planning side. That's kind of, as they say, you want to make sure all your ducks are in a row. Yeah. And so what are some things that people that you see as an estate planner, what are some things that people do prior to the death of a spouse that really makes that transition from 2 to 1 much easier on them, and then also the children and then the legacy they were building together?
I mean, the biggest thing is having some sort of documentation in place. We're always big about trust. We talk about that all the time here with our firm. But I mean, even if you don't go that route, at least having a will and a legalized will for your state. Louisiana is a little different. We've got the Napoleonic Code, so someone can actually handwrite their own will, but there are some deals that you have to do with that for it to be legal in the state. So you need to make sure you look up properly how to do that if you want to do the handwritten route instead of going to a lawyer and everything. Florida does not, respect that kind of deal. They're not governed by the Napoleonic Code, and they're like most every other state where you do have to have it a legalized document, not a handwritten document. And then, other things, too. We're now living in an age where people are on their second, third marriages, have, some children from previous marriages, and also maybe some children from their second marriage and stuff like that. So the more advanced your family is in these different stages, I would say the more advanced your planning needs to be for your legacy after you pass.
And one of the things I know that you guys on the estate planning side always tell our clients or people that you're working with is it's not a great conversation, but having that conversation while you guys are both still living, letting the next generation know where these documents are, who they need to talk to, what steps they need to take.
That's one of the biggest keys right there that you said. Not only do you need the documents, you need to know your surviving people know where those documents are. A lot of people, I've got safely locked away in my safety deposit box at the bank. Great. Who has a key and access to that? Do your children know that you have a safety deposit box at your bank? And if so, how do they get into it? Are they on the account to where they can get in there should you pass? So I mean, it's great if you have these documents, but if you lock them away and nobody can get to them, they don't really do you any good either.
That's correct. Now, that is really good advice on the estate planning side. Definitely some steps on the wealth management side that I think work almost hand in hand with the estate planning side. As you mentioned, if you're on your second or your third marriage or things like that, making sure that all your beneficiary information is up to date and is correct. Make sure those insurance policies that you purchased 10, 20 years ago reflects how you want things currently. If you've done any type of estate planning, have you actually taken that packet and done what you need to do with it outside of our office? That's always important too.
I was actually sitting down with a gentleman last week, and we were reviewing an estate plan for him. And with that, we kind of go over insurance policies and different things of that nature. And like we said, a gentleman on his second marriage, and I was like, okay, well, great. You got your beneficiaries for your life insurance. Who is that? Well, it was the first wife. Is that who you still want to receive the insurance? Well, he had moved on, and he wanted the second wife to be able to receive it. So it's just little things like that. You get these policies and years and things happen, and everything gets in the way, and it just falls to the back of the mind. So it's just really great to also pull all that out, at least once a year, and just review it and make sure everything's up to date where you want it.
And one of the things too that we like clients to do is let's stress test the plans that you have at a death of a spouse, right? Going from a joint tax bracket down to a single tax bracket, losing one of the Social Securities, right? These are all things that are going to have a change to the way that you do business day in and day out and live your life, so that no one wants to live it, but you need to make sure that when that time does come, you've done all the homework up front, so now you know what to do. And one of the things that I think that having a firm or someone that can do the estate planning and the wealth management side together is making sure that some of those small things like deficiencies in like the beneficiaries or the estate planning side, those nothing gets left, because as all of this whole plan's coming together, right? We're stress testing on the wealth management side. We're making sure that we're not leaving anything in the wrong name or beneficiary standpoint in the estate planning side. So at the end of that, they can sit down and have that conversation with that next generation of who they want their assets and their legacy to go to. To kind of close up on that, is there anything that we may have not touched on, or anything that you can think of that could really help?
I mean, a lot of people too that I sit down with, especially here in Louisiana portion of things, we're the common law state, so people just automatically assume everything will be transferred over to the spouse at their death. And for the most part, that is correct. Okay. But there are a few little caveats to that. Like if you have children, the children are actually the owners of your deceased spouse portion. You just have use effect of it until you're passing before it becomes full ownership for your children. Mm-hmm. So if you don't have something in there that actually gives the spouse the full ownership of it, she would still have to get the children's permission if she wanted to, or sell the house, downsize to something smaller, that nature. In Florida, it follows something completely different. Theirs are the equitable distribution rules, what they follow over there. And you would think that's maybe 50-50. That's not necessarily the case. They look at it, and they have all these little stipulations. You got to check these little boxes in order to receive full ownership of everything there. Otherwise, it's distributed through children and siblings and other things of that nature. So just because you might assume these things, I would still sit down with a professional and make sure that what you have would follow suit with what your wishes are.
So if you've gotten a trust or some type of estate planning done in a different state, now you live in a different state, that is worth your while to have that reviewed?
Well, the trust itself should work in every 50, well, it's not should, it will work in all 50 states.
Of course.
But if you're just going with the will route, then you definitely, and you move to a new state, you should definitely have that reviewed by an attorney that is licensed in that state to make sure that it's up to date to those laws, because the wills are governed by the states.
Of course, okay. That is great information. Dave, as always, I enjoy having you on Coffee Chat, and look forward to having you again next time.
Yep.
Thanks, sir.
Thank you.